any of these three defendants at any point in time. The evidence that's been presented is that Mr. Bryan and Mr. Gregory McMichael never once said, we're making a citizen's arrest, that we're placing him under the arrest for the crime of this, that we saw him commit a crime that day. That was not it. It was all, we wanted to stop and talk to him, and then we wanted to detain him. In fact, Mr. Rubin said in his opening statement that the intent was to detain him so that the police could show up and do whatever they were going to do after the detention. It's not citizen's detention, it's citizen's arrest. So while he talked about that, that is really not something to be considered in a directed verdict motion. And just because a set of facts hasn't yet been specifically identically brought before a court, these sets of facts, no two cases are going to have the same set of facts. They're just not. And so the fact that there is felony murder based on false imprisonment case law out there, where someone has been found guilty of felony murder based on false imprisonment, someone's been found guilty as a party to crime based on aggravated assault with a shotgun, someone's been found guilty of party to a crime for aggravated assault with a motor vehicle. Those cases are out there, maybe not with these specific facts. So that argument doesn't really hold water either. In this particular case, when it comes to Mr. Bryan, and this will apply for all of the charges here, once again, it's party to a crime, and that means intentionally aid and abet. His statements to Agent Seacrest, and actually at the scene to Officer Minshew, were about, I thought they had done something, I thought I was trying to help them get this guy, false imprison this guy, capture this guy. And that was what his intent was. It was to falsely imprison this particular person, and he intentionally used his vehicle to go ahead and do that. Both on Burford, when he intentionally committed an aggravated assault, putting Mr. Arbery in reasonable apprehension of receiving serious bodily injury as part of his attempt to falsely imprison him on Burford. Those two things contributed to his death because but for those things happening, Mr. Arbery would still be alive. So it is, as the pattern charge will be given, his actions played a substantial and necessary part in causing the death, because without him doing those things, Mr. Arbery would not have been trapped like a rat over on Holmes Drive between the two pickup trucks. As we noted before, malice chased him through the public roadways in the pickup trucks, tried to stop him, cut him off with the pickup trucks. He drove him into a ditch. He assisted pinning him between the two pickup trucks, trapping him like a rat between the two pickup trucks. Mr. Arbery had not threatened anybody, had shown no aggression. Mr. Arbery had no weapons. He was totally unarmed. And here, Mr. Bryan never called 911. He continues pursuing Mr. Arbery. Mr. Bryan never says anything on the recording. He pulls forward despite the shotgun coming out, despite the shotgun being pointed at himself, doesn't slam on the brakes, doesn't yell, doesn't protest, doesn't honk, just keeps driving forward, driving Mr. Arbery forward. He helped to get Mr. Arbery to this location by redirecting him up Holmes. The most important thing is when you have common criminal intent, and here the state's position is that as parties to the crime, there's common criminal intent to attack Mr. Arbery via false imprisonment, aggravated assault with the pickup trucks, aggravated assault with the shotgun, and false imprisonment ultimately on Holmes. And that common criminal intent to do all those things, not necessarily the conspiracy. I'm not talking about conspiring in advance and coming up with a plan as we sit around the kitchen table. We're talking about what they actually did, acted in concert with each other. The white truck came down Holmes. Mr. Bryan was going up Holmes. Mr. Arbery had already turned around and was running back, and the white truck passed him. Mr. Bryan did not abandon this. He turned around. He kept going, and then he accelerated to catch up to Mr. Arbery, passed the blue mailbox, saw the shotgun, and kept going. Common criminal intent, which resulted in malice murder, resulted in all the felony murders. All of his actions did substantially contribute to the death of Mr. Arbery, and they were necessary because without those actions, Mr. Arbery would be alive. We ask that you deny the directed verdict for all of the counts as to Mr. Bryan. Thank you.
Any final word from Mr. Bryan?
Your Honor, when the state is constrained to acknowledge that they have no legal authority for their position, for example, on malice murder, then I think the court should take seriously the motion to grant the directed verdict. There is no malice murder case against Mr. Bryan. With all due respect to the state, there never was. That there are some other issues in the case that are more challenging and more troubling, but that's an easy call. I think it's an easy call on count 2 felony murder for Mr. Bryan only. Again, the state has no fault. It doesn't even pretend to give an explanation as to how Mr. Bryan, thinking that he's aiding a citizen arrest lawfully or unlawfully, how that translates into an intent to shoot or an intent to injure. And it's deeply troubling to me that the state can't have the candor to acknowledge to the court that maybe in retrospect, counts 1 and count 2 as to Mr. Bryan were not well thought out. There's no proximate cause. There's no reasonable foreseeability here. I'm impressed with the argument that was made, but still, Mr. Bryan is entitled to a directed verdict, certainly on count 1, almost certainly on count 2, and arguably as to every count in the indictment. Thank you.
And Your Honor, I apologize profusely. I had pulled up a case and I forgot to cite it. And it is both the state of Georgia, well, Moore versus the state and Milburn versus the state. It is 311 Georgia 506. And in this particular case, a group of men wanted to rob a drug dealer, and one person stayed downstairs to keep the boyfriend away while they went up to go ahead and search the apartment. Unfortunately, the girlfriend was in the apartment, and the two that went up there, one executed the girlfriend. They came downstairs. The state obtained a malice murder conviction on the man downstairs who simply kept the boyfriend from protecting the girlfriend upstairs. And that is a case that does show someone who doesn't have their finger on the trigger, who's downstairs doing some other action, the same sort of criminal intent, which we feel that's here, same criminal intent to falsely imprison, aggravated assault with the trucks and with the gun, can be convicted of malice murder. And that's the case we cite to. I apologize for not having brought it up further earlier.
I'm sorry, was there a citation for Milburn, or are we abandoning that at this point?
No, Moore and Milburn are co-defendants, and it was a combined case, and
Okay.
so it is the same case. 311 Georgia 506 out of Cobb County, 2021.
Again, Your Honor, that case doesn't even get close here. That is in line with the other cases, what I call the distraction line of cases. It's basically the same thing. In this case, it's distraction plus, in that the person who's being charged is holding, basically, a third party who could otherwise and would otherwise go to the defense of the person who's killed. Mr. Bryan is sitting out there in his truck armed only with a cell phone. He's not holding anybody back. He's not saying, Mr. Albenza, you stay back there. There's nobody else on the scene. This is a case where someone is actively preventing this. Moore v. State is a case where someone is actively preventing a third party from coming to the aid of the person being killed upstairs. That is completely irrelevant and totally off base. And again, Your Honor, if that's the best the state can present to the court, then I think the court is constrained to grant the directed verdict as to count 1.